Federal Judge Eileen Cannon just issued a new paperless order inviting certain non-parties to participate in oral arguments before her court on June 21st, 2024 in connection with the Mar-a-Lago document case. These non-parties, she would like to have them argue about whether or not the special counsel, Jack Smith, was unlawfully appointed, and therefore whether Jack Smith and the entire prosecution team should be removed and the case dismissed. Donald Trump filed a motion to dismiss on the basis of the unlawful appointment of special counsel Jack Smith. This is the type of tinfoil style legal arguments that should have no place before a district court. It is as frivolous as can be. It would not even need a hearing date. It should just be rejected out of hand and frankly sanctionable. But not only is Judge Eileen Cannon holding a hearing on this, she's asked for supplemental briefing, and now she's invited non-parties to show up in court, just like third parties, to make oral arguments in formal proceedings before the court, which is essentially entirely unprecedented. She's just making this up as she goes. Here's the paperless order so you can read it for yourself. It says, paperless order granting motions for leave to participate in oral argument as to amici curiae, the representatives designated in the respective filings will be permitted to appear on behalf of amici curiae and present oral argument at the June 21, 2024 hearing on defendant Donald Trump's motion to dismiss the indictment based on the unlawful appointment of special counsel Jack Smith. Approximately 30 minutes are reserved for each, seating to be reserved for representatives presenting argument, signed by Judge Eileen Cannon. Now, the submission of what's referred to as amicus briefs or friends of the court briefs, that's not entirely unusual. It's less common in district court proceedings than you see in the Supreme Court, but third-party groups submitting filings to a judge in a court case is something that occurs, but having those parties actually participate in the proceedings and show up at hearings for oral argument is something that is so rare and so unusual. There is quite literally very precedent for it at all. In fact, where the Supreme Court has opined on it, the Supreme Court has discussed how disfavored it is. And so, here's basically the order of events of what went down. So on May 31st, 2024, there was a motion for leave of someone named Professor Seth Barrett Tillman and the Landmark Legal Foundation to participate in oral arguments as amici curiae. So, and they're supportive of Donald Trump's view, and they're one of these right-wing extremist groups pushing that there shouldn't be special counsels, the appointment's unlawful, the case is unconstitutional because of the unlawful appointment, and therefore the case should be dismissed. So then another group, Citizens United, the Citizens United group, joined by some other right-wingers who previously held positions in government, Citizens United and these other people, they then filed their own motion for leave to participate in the oral argument. So then one of the groups saying how crazy this is and what a ridiculous argument this is in the first place, that is opposing Donald Trump's claim that the special counsel was unlawfully appointed, and says, what are you talking about? Of course, the special counsel is lawful. So this group that's rejecting Trump's effort to dismiss the case, they then realize, who knows what Judge Cannon's going to do, so we should at least request that we show up at oral argument if these other groups are asking for it as well. And it was good that they did, because Judge Cannon, they did that on June 3rd, by the way. And then Judge Cannon said, okay, let's have all these random third-party groups show up at the oral argument and let's have them just discuss these issues of a potential unlawful appointment. Just so you see some of what these arguments here and what they're actually trying to even say. Take a look at this. This is the group, the Landmark and the Professor. They say on February 22nd, 2024, defendant Trump filed a motion to dismiss the indictment based on the unlawful appointment. On March 21, 2024, a proposed amicus brief from Professor Seth Barrett and Landmark Legal Foundation was docketed in this case. The brief contended that the special counsel's temporary position is properly characterized as a mere employee. Special counsel Smith does not hold an office, and he is not an officer of the United States. Both procedurally and substantively, the actions taken by special counsel are ultra vires with respect to the Constitution. And then it goes on to say how the position held by Smith was not established by law, and the authority exercised by him as a so-called special counsel far exceeds the proper and permissible exercisable power as a mere employee. And it says that Jack Smith is not an officer under the statutes cited by Attorney General Garland. At best, he is an employee. So that's what they're arguing. And it's like a wacky argument. And Judge Cannon, though, is like, I want to hear it. I want to see if special counsel Jack Smith is unlawful, and I'm going to make a ruling on that. On her own, sua sponte, she also requested briefing from the parties on the following issue. She goes, in anticipation of the June 21, 2024 hearing on defendant Trump's motion to dismiss the indictment based on the unlawful appointment and funding of special counsel Jack Smith, the special counsel and defendant Trump are directed as follows. On or before June 11, 2024, the parties shall separately file supplemental briefs not to exceed 15 double-spaced pages on what impact, if any, the Supreme Court's decision in Consumer Financial Protection Bureau, CFPB v. Community Financial Services Association of America, has on defendant Trump's Appropriations Clause challenge as raised in the motion. The parties' supplemental briefs also should clarify in a separate section what appears to be the position set forth in the party submission, that no factual development is warranted or necessary to resolve either of the two challenges in the motion, because the extent of the special counsel's authority and status is delimited and evaluated by the statutory and regulatory authorities cited in the Appointment Order 5559-2022 for purposes of the Appointment Clause challenge, and by the same Appointment Order and the cited Department of Justice Appropriations Act for purpose of the Appropriations Clause challenge. The court also authorizes but does not require the 3 already approved amici on the motion, and only those amici, to file by June 11th deadline supplemental briefs reasonably limited to the factual development questions raised above. So I mean, she sends them on these wild goose chases. Like, remember when she asked special counsel Jack Smith a month or two ago, can you please grapple with the question about whether or not Donald Trump's behavior should be immunized, and what jury instructions should be provided to inform the jury of the special benefits that Donald Trump has? And Jack Smith's like, what are you talking about? You want me to send proposed jury instructions now about something that's unlawful, that Trump's able to steal national defense information and top secret documents and nuclear codes? Like, let's use the model jury instructions. And by the way, you're the judge. What are you doing by having random non-parties show up, third parties show up and make oral arguments on a topic that is so wackadoodle and so out there that it shouldn't even merit a hearing in the first place. And you're going to bring these parties to non-parties to argue in a court of law. What is it? It's like a club. It's just like a nightclub. You just invite randos in to show up and, hey, you want to make an argument? You know, I mean, could you imagine at just another court proceeding, other people showing up and making legal arguments? I mean, look, you've got two amici for Trump, one against Trump that's going to be there. But this whole fact that they're making oral arguments is like just a ridiculous thing and just shows that, again, Judge Cannon doesn't know what she's doing other than how can she help Donald Trump. That's clear. That's her main focus here. Anyway, I'm Ben Meiselas from the MeidasTouch Network. Hit subscribe. Let's get to 3 million subscribers together. Thanks for watching and have a good day.
Enough! Send him to the big house, not the White House. Get the new exclusive tees, mugs, and stickers right now at store.MeidasTouch.com. That's store.MeidasTouch.com.